I would like to address some preliminary issues.
Please do.
That he raised, and then I'll talk to it. Yes, typically in a criminal matter, before a decision is made by the prosecution as to whether to take a case to court or not, both the Ghanaian system and the English system, where we borrowed our common law from, there are two tests that the prosecution would use to determine whether to go to court in the first place or not. The first test is what we call the evidential test, and the second test will be the public interest test. Different jurisdictions might call it different names, but all common law countries use these two particular tests. I'm starting this because of he has made some statements and he has tried to impute whether there is a motive as to why the Attorney General is bringing the case in the first place. I remember him mentioning the moment the Ato Forson said something about the e-levy and other things. That was when the Attorney General initiated it, even though they had gone to ECO, which initially had contact with them, listened to them, and let go. That's not how criminal trial actually works. So you might listen. So criminal prosecution could start with a mere suspicion. And as time goes on, evidence begins to trickle in. Then it will get to a point that it might raise some interest as to whether it is worth investigating. Initial inquiries, either by different state departments, might conclude there might not be evidence. But as time goes on, the prosecution will gather more evidence to say that maybe it raises to a level that they might have to have a second contact with you. And I don't know at what point the Attorney General really had a second contact with him. But it's quite normal for prosecution to start as the evidence gathers. So it's clear from what he said, at some point the Attorney General, I don't know what happened behind the scenes, but based on us when he was contacted or called, it could be coincidental. We cannot just input a motive to it. So if there's enough evidence, sometimes it's not enough for prosecution to go to court. You then have to ask yourself, is it in the public interest to actually go to court in the first place? For example, in the UK, there had been cases whereby a mother killed the child. But the method at which the mother used in killing the child, if you hold a trial for people to get to hear this particular case, some people might imitate using similar things to kill people, especially when she said it was a mercy killing. The child is in permanent pain and all those things, and out of compassion, a mother decides that I want to kill this child. Using methods that, if it comes in the public, more people might use it. In that instance, a prosecution will probably say, if you can't hold the trial behind closed doors, then it might not be in the public interest to even bring this case. Because in an attempt to save one person's life, you end up in killing more people because people will adopt that particular method. It's for this reason that the prosecution always have to use these two tests. If there's enough evidence, you then ask yourself, is it in the public interest to proceed? And from what I have gathered so far, the Attorney General probably applied both tests. And in his wisdom, and as a chief prosecutor of the country, he decided, yes, there is enough evidence to proceed. And that was why this particular prosecution started in the first place. There had been enough information about this trial in the media. One of them would be the tape issue and the fact that there was attempted plea bargain. There has been a lot of noise about plea bargain, as if it is completely unethical. It's not. If you look at other jurisdictions, the UK, the US, look at the trial of Donald Trump, the president. Michael Cohen had a deal with the prosecution. So it's not unusual for a prosecution to have a deal with somebody to reach a plea bargain. Plea bargain has its benefits with some few drawbacks. For me, the benefits outweigh the drawbacks. One of these is that it can save a lot of costs for the state.
Are you suggesting, Ishaq, that
yes,
the tape we heard
yes,
had to do with the plea bargain arrangement?
I'll come to the tape, but then there was an issue that there was a plea bargain. I think Japan made an attempt to say that there was a plea bargain for him to tender evidence against Ato Forson.
No. Okay, that's not the impression I got. I thought that there were two separate issues.
No, there were two separate issues, but we are dealing with the two cases together, both Ato Forson and that of Japan.
Yeah.
But what I'm just talking about, the fanfare surrounding the whole particular thing. There seems to be a suggestion that plea bargaining is an unethical thing. The point I'm making is that
our law allows it.
Yes, the law allows it, and elsewhere it's being done. So Ghana is not in isolation if they try to do it. And as I said, it has its benefits.
Right.
One of the benefits will be saving cost.
Yes.
And also, if there is a bigger fish to fry, such as if the prosecution think Ato Forson really is very, very important in such a, maybe the amount of financial loss he has caused to the state is worth pursuing. And if offering carrots to that of Japan could help nail him down. There's nothing wrong with that. Elsewhere, as I said, it's been done. Now, coming back to...
But it must be done, you agree that it must be done within the strictures of the ethics of your profession?
Yes. For example, there must not be undue pressure. And from what I've heard, there's none.
I mean, the Attorney General cannot ask Japan to go and fake ill health and take a medical report to come and deceive a judge.
Oh, that one I've heard, yes. I have difficulty with that aspect when it comes to ethical issue. But the subject matter itself that there was an offer made to tender evidence against Ato Forson. There's nothing wrong with that. It's done most common law jurisdictions is done.
True.
Now, having said that, let's come to the trial in the High Court.
Right.
So the High Court judge, having listened to the defense statements, the defense, as he rightly said, have tendered various evidence and they stated various facts. The High Court judge, as she also rightly said, she's not just sitting in the High Court as a High Court judge. She's a Court of Appeal judge with additional responsibility to sit in the High Court. She was present throughout the process. She reached a conclusion that there is a case to answer. Now, that is exactly what they have appealed against, isn't it?
Yes,
now, she listened to them. For me, in my opinion, the decision that she made was actually correct. Because if you look at, especially if you look at this press release, the Attorney General has stated most of the argument. This is a summary of the argument they put before the High Court judge. The High Court judge accepted these particular submissions and came to the conclusion that there is a case to answer. And I think this is not a high bar. In a criminal case, the finding of whether there is a case to answer is not a high bar. It's not that it's beyond reasonable doubt. It's not that there might not be errors in the prosecution's case. There could be. But at least the prosecution would need to establish that, taking the prosecution case at its highest, there is likelihood that there will be finding of guilt. And from my own analysis and listening to the case and following it, I must admit he will be familiar with the case more than me because he is actually involved in actually dealing with the case. I am not. But having heard what I heard in the media and what I read, and the test to apply taking the case at its highest level with what the facts and the evidence are used by the prosecution, I think there is a case to answer. And that brings me to whether the Court of Appeal have made the right decision. Now, the Court of Appeal, I think it was a 3-member panel who have sat in the case. The presiding judge dissented, and the other 2 agree that there was no case to answer. I've not had opportunity to read the judgment fully, but I've seen few excerpts. And one of them, there seemed to be an imputation of fact from Ato Forson by one of the judges, which I think is wrong. For example, the judge made the claim that Ato Forson never said he authorized, he authorized the purchase of the ambulances. If this is what the judge is saying, it's like he has gotten the information from the media. Because Ato Forson never had opportunity to open his defense. So where are you getting it from?
No, let me just
I mean, he's getting information from the media, of which a judge shouldn't be doing
No, that's incorrect. You see, cross-examination does 2 things. To put your defense across. And also to undermine the case of your adversary. So under cross-examination of the Bank of Ghana official, We then suggested to him that have a look at the letter Ato Forson wrote on this.
Have a look.
That's the witness.
Okay,
the prosecution witness.
Okay.
So have a look at the document. It's dated 7th August 2014. So when he looked at it, then we now put it to him that in the letter you have seen, where did Ato Forson say, I'm authorizing Bank of Ghana? Then he said, obviously from the letter, he didn't use authorized.
Okay, let me develop the point from there. And he also mentioned certain things like he requested and not instructed. I think we are going to play with semantics. It's better there's evidence of the letter. That reading the content of the letter and the context would help us determine whether it was his position to even make a request in the first place. If a request is coming from a minister to an executive of Bank of Ghana, why make such a request? If I make similar requests...
It's a procedure.
Yes.
It's a procedure, not that... If any ministry, in this case the Ministry of Health, incidentally,
yes,
we are actually dealing with an ambulance matter now,
yes,
as we speak.
Yes.
And the request for the payment of 34 point something.
Yes.
The first request,
yes,
as we are told by the Ministry of Health, came from the Chief of Staff.
Yeah.
Asking the Ministry of Health to assist the ambulance service because the special initiatives did not get their budget approved by Parliament. So they should assist them to run the place.
Okay.
On the basis of that, the Ministry of Health asked the Finance Ministry to fund the 34 point something million.
Okay.
The Finance Ministry says we can only do 10 million.
That's a defense case.
No.
I'm just giving you an example.
Okay, an example.
So I'm just trying to tell you where the request emanates from. So in the current ambulance case we are dealing with, the Finance Ministry did not sign an ambulance contract.
Okay.
It is not the supervising ministry for the ambulance service. But the request came from the Ministry of Health. So the Ministry of Health told them that we have a contract with this, the ambulance service has a contract with this company. We want you to fund the 34 point something million.
Yes. But the prosecution case is that he actually instructed.
Instructed what?
I mean, he actually instructed, the Ato Forson instructed Bank of Ghana and the controller and accountant.
Yes, so that is why if you were listening to it.
Yes, I listened to it.
When you read, he indicated that on the Bank of Ghana document.
Yes. I'll deal with that.
You will see who actually initiated it, who's requesting for it. And you will not see Ministry of Finance. So I was just giving you this as an example. That ambulance service, also Chief of Staff, it goes to Ministry of Health. Ministry of Health informs Finance Ministry that there's this contract. We need the funding for it. Ministry of Finance says, okay, I can do 10 million. Then it writes to the Accountant General to do so. The Accountant General then goes to Bank of Ghana to do same. But obviously, the request for the payment emanates from the Ministry of Health, not the Ministry of Finance.
Okay, yes. Having listened to you, I would like to proceed further as to the other aspect. Now, you can see that it's more or less a split decision. You have to remember that the judge who presided over the High Court is a Court of Appeal judge.
Yes.
And then there's another Court of Appeal judge who dissented, even though it wasn't in the same sitting. But that tells me that it is actually in the public interest for the Attorney General to actually appeal the decision. And he did indicate he would appeal. While he should respect the decision of the Court of Appeal, nevertheless, I think it's in the public interest for him to appeal against the judgment. And that is actually in the interest of the accused. If you really think you are being persecuted, let the final court, the Supreme Court, to have their final say. And that would actually exonerate you completely.
Right.
Yes.